Yeah, so at this junction, we invite Barrister Judge Amadi to give the address regarding latest immigration updates. Barrister Judge, over to you.
Yeah, thank you so much, uh, Brother John. Thank you so much. And I really want to appreciate what Like Minds is doing and what you are doing through Like Minds. Really fantastic. And I hope to do more collaborative work with you as time goes on. I really appreciate it. And I welcome every one of you in Like Minds and everyone that probably will listen to this recording with time. Uh, I'm trying to share my screen so that you can get to see what I have. And I don't know if you're seeing my screen, just wave to me so I know that you're seeing my screen. All right, thank you so much. That's good. So, today I'll be doing a very short presentation to update us on the 2025 new immigration updates. What's going on? A lot has been going on since last year. We did a bit of an update last year, and since then there has been a lot of changes and so many things happening. And it's really amazing all that has been going on. There have been so many changes that the last time I spoke to John on this matter, I said that, well, the truth is that even this update we are doing now, there are possibilities that by tomorrow, uh, you might be surprised that things have changed again. So it's quite interesting the way things are changing in the UK. The everything changing every day, you know. So we just have to, I need to give that caveat to let you know that things might change again. So when you see, sometimes we've done an update, and the next day the Home Office comes up and say that things have changed again. So it's very important for us to understand that what we are saying now is as it is now. So things might change in the future. So please let's do understand this. So as we know, on the 12th of May, the government published a white paper, which was a kind of, which made a lot of noise. And the white paper was something that a lot of people called me about and talked to me about. So they published a white paper policy document called Restoring Control over the Immigration System. The document proposed some changes to make it harder to move to and settle in the UK with a view of reducing immigration. Now, a white paper does not by itself alter the law or the immigration rules. It puts forward changes the government intend to make in the future. Some of the white paper proposals have been implemented since May, but most of them are yet to be implemented. There were 8 major areas that the white paper looked at. One of them was shortening the list of jobs for which employers can sponsor a worker from overseas for a skilled worker visa. Jobs assessed as being medium skilled, as RQF levels 3 to 5, will not be sponsorable unless the Migration Advisory Committee recommends an exemption and the industry is demonstrating efforts to recruit domestically. So there has been an emphasis on domestic recruitment. Second issue on the white paper was ending an existing exemption for social care workers. Employers will no longer be allowed to recruit from abroad. Uh, The third thing on the white paper was exploring a levy on English universities income from international students' fees. For making it harder for universities to keep their license to sponsor students' visa by introducing tougher compliance rules. Five, reducing the standard length of the graduate visa for international students to stay on and work in the UK from 2 years to 18 months. We're going to look at some of this very soon because some of them has been implemented right now. Six, stricter English language rules, higher standard for those already taking language tests, and requiring the partners of people moving to the UK on work visa to have basic English to qualify for a dependent visa. Seven, increasing the standard qualifying period for permanent residents, also known as indefinite leave to remain or settlement, from 5 to 10 years, with some people qualifying sooner based on criteria yet to be decided. This one is also still being looked at. It has not yet practically taken effect, although the government is having a lot of pressure from Reform Party on this matter because Reform Party is threatening to, if they win the next general election, to totally abolish the indefinite leave to remain procedure. So that's quite a kind of they are pushing them by the side. And so the current government seems to want to take action on this. Eight, making it easier for people to come to the UK on certain visas aimed at higher skilled migrants, such as the global talent and higher potential routes. Most of these changes can be made by amending the immigration rules. They do not require an act of parliament except for levy on student fees. Now, the white paper is a wide-ranging document and covers many other issues in addition to the examples that we've listed above. This includes a new labor market evidence group, reforms to family and dependent visa, Article 8 of the European Convention on Human Rights, and the deportation of foreign national offenders. So we're going to be having looked at the white paper, which brought a lot of threats to migrants last time. We also have a lot of issues. There are so many things, coming up right now, which we also need to look at. And I'm going to give a brief summary of some of the things that have been implemented since 2024. I'm going to kind of combine both of them since the new rules that are affecting people currently as things stand. So the first one, significant changes to UK immigration rules have been introduced in 2024 and 2025, largely driven by government objective to reduce overall net migration. The reforms primarily target work, study, and family visa routes, with key measures including higher salary and skill thresholds, restricted visa eligibility for specific roles, and a move towards digital migration. Key changes for work visa. So we have increased salary and skill threshold, higher skilled worker salary effective from July 22, 2025. The general skilled worker visa salary threshold for new application increased from 38,700 to 41,700. So this is quite important. Graduate level level skills requirement. The minimum skill level for a skilled worker visa was raised to a graduate level, regulated qualifications framework. Six, this removed 112 occupations that were previously eligible. So that's another very important change that took place. So then, of course, as we are aware, anytime the Home Office does anything, changes the rules, there is always a transition period. There's always transition arrangement. Like people always ask, are these things, once they change this rule, is it going to affect me right now? I know somebody called me last week and was asking about this. I was so worried about the indefinite leave to remain stuff. Is it going to affect me if they change it right now? I said, no. If you're already in the UK under any old rules, the UK government does not apply their rules retrospectively. They do not go back and say, okay, those of you that came 2 years ago, 3 years ago, or even this year, that is going to affect you. It will usually they start implementing their rules from the very date that rule comes into force. So people should stop being scared of rules that have changed and saying that it's going to affect them and all that. So the transition arrangement, workers already in the skilled worker route before April 4, 2024 are exempt from the highest salary threshold when they extend their visa or change employers. Those renewing their visa must still meet an updated, albeit lower ongoing rate for their role. So I'm going to talk about this transition arrangement a little bit later, but let's just finish with what I have to say here. So changes to the health and care visa. Um, there's an end of new overseas recruitment. As of July 22, 2025, new overseas application for care workers and senior care
Mm.
workers are no longer permitted. I'm sure we are all aware of that. Dependents restricted since March 11,
That one.
2024. Care workers are banned from bringing dependents,
Yeah.
spouse, partners, and children to the UK. So, of course, there's also transition arrangements on this one. So, a transition period until July 22, 2028 allows those already in the UK to extend their visa, but the route is being phased out. So, there's always a transition period, like I said, because some people also don't know that if you were granted leave to enter into the country as a care worker and you were allowed to bring in your partner and your children as dependents as part of that visa, there is a transition period for you. So the change of rules does not technically mean that you can no longer bring them in. There is a transition period that expires on the 22nd of July 2028. So this should be taken into consideration. So the salary list reforms, revised immigration salary list. The former shortage occupation list was replaced with a smaller immigration salary list on April 4, 2024. So that's also with fewer roles qualifying for a reduced salary. New temporary shortage list. An interim temporary shortage list was introduced on July 22, 2025 for a limited number of below degree level jobs. Workers sponsored on the TSL cannot bring dependents. So that is quite important. Changes to study and graduate visa, dependence of students banned. So effective of January 2024, most international students, I'm sure we are all aware of this because this was done in 2024, can no longer bring dependents to the UK. This applies to all new students with exceptions for those on postgraduate research courses. So graduate visa length reduced. This is very new and very important for us to understand. Proposed changes outlined in the May 2025 Immigration White Paper include reducing the graduate visa length from 2 years to 18 months. A review of the visa found no evidence of widespread abuse, but the government has committed to implementing the reform. So tougher uh, compliance for universities. Sponsoring institutions now face stricter rules and potential students recruitment limits if they to failing their sponsorship duties. So if they fail and they fall below the expectations, they will face penalties. Family and settlement visa reforms, higher minimum income for family visas. The minimum income requirement for British citizens sponsoring a partner or spouse increased from 18,600 to 29,000. in April 2024. Ended settlement qualifying period proposed. Extended settlement qualifying period also proposed. The May 2025 white paper proposed increasing the standard qualifying period for indefinite leave to remain, that is settlement, from 5 years to 10 years for most work visas. A consultation on this end settlement scheme is planned for later in 2025. So exemptions to settlement changes. The proposed settlement extension does not apply to partners of British citizens, EU settlement scheme residents, or victims of domestic violence. So while the white paper is proposing for extension of settlement qualifying periods from 5 years to 10 years for most people on work visa permits and all that, this proposal will not affect people who their spouses came to the UK, probably British citizens of spouses of British citizens, EU settlement scheme residents, and also people on the that are here as victims of domestic violence. So other notable changes: moves to e-visa that I'm sure most of us have transited to e-visa. The UK is transiting to digital immigration system, with e-visa replacing physical documents like biometric residence permit for most new visa applications from July 15, 2025. So now, if you are granted some sort of leave, you will no longer receive the normal biometric card that comes with it. All that you do, because a lot of people now get their leave and they ask, what do I do next? You go to to online and of course register for your e-visa, and you will have your e-visa. With that, you can travel with your normal identity documents, and that is what has been or will be implemented. It's already been implemented, but then from this July of this year, it's nobody's going to be receiving um, uh, biometric cards anymore. Originally, I think the Home Office phased out the biometric cards in December last year, but then extended it to July this year. So that's what's obtaining now. So higher fees for visas, certificate of sponsorship, and immigration health surcharge have all increased this year. I'm sure you must have noticed that if you have applied for renewal recently, you will discover that there has been an increase in the fees you have to pay, and stricter language requirement. English language requirement standards will eventually be introduced for both visa applicants and their dependents, taking note on the line, their dependents, which was not the case previously. So dependents will now be required to also apply for to meet the English language requirements, which was not the case originally. So increased enforcement, of course, the government has pledged to increase enforcement and penalties for those who abuse the immigration system, including employers who fail to comply. So these are some of the new changes. Some have been implemented, some have not been implemented, but are being considered very quickly before the end of the year. You are going to witness a lot of other changes as well. Like I said at the beginning, the changes to the immigration rules are moving as far with the speed of lightning. And unfortunately, while we were still contemplating the changes that were done by the last Home Office minister, we had a change. The Home Office minister was changed a couple of weeks ago. So, which automatically means that we should get ready to witness another wave of new immigration rules. So this for now will be, I'll stop here on this and hope that this brings us to brings us up to date with what is happening in the country, in the UK so far. So I'm going to probably throw it back to Ross if you have Any questions? You have uh, anything that you want us to put some emphasis on or to discuss? This will be the time for us to raise those questions, and then we'll be able to deal with them. So thank you for listening, and I hope you were able to benefit from this presentation. My
Yeah,
name
thank
again is
you.
George Amadi, has been introduced by John, and I'm the lead immigration lawyer for Eden Immigration. We are based in Luton area. So yeah, that's where we are. Thank you
Could you
very much.
share your details, contact details on the chat as well?
Yes,
But on that note, though, I want to entertain questions. I know people have a lot of questions. So I think that we decide to make it not too lengthy, so we could
brilliant. Yeah.
create time to address practical scenarios, practical questions. So you could either ask the question or put on the chat, so I can read the chat, or you could put it on the chat, so we'll just go from there. But let me start by kicking it off by saying the 5 to 10 years. Um, I'm assuming it's not, has it been implemented now? Maybe, for instance, if I'm due for indefinite, let's say tomorrow or next week, does it affect me now? Does it affect myself? Or does that mean after for another 5 years? Or has the process been concluded? And when would that, or if not, when would you think it take effect?
No, it's that is a very interesting one, but it's not been implemented.
Hmm.
One thing that it was part of the white paper proposals. It's not been implemented, but most likely will take effect. But the problem again with this proposal was that the white paper was introduced by the immigration the Home Office minister who has just been replaced. So we do not know. So there are three problems with that proposal. One is that we now have a new Home Office minister who may not go in that direction. That's one thing there. The second one is that the original intention was to implement it before the end of the year, 2025. And then the third thing I need to point out there was that even if it goes ahead, like I said in the presentation, there's going to be a transition period. And transition periods usually means that everyone who is already in the country will not be impacted by that change. So the only government that might apply this rule retrospectively will be reform if reform comes into power, and that is what they have threatened to do. That if they win the next election, that well, I'm going to, okay, I've seen what you've written down. I'm going to just propose both of them to answer the questions together. So if the current government implements it, it's not going to be retrospective. It's going to apply straight from the day it was implemented, the day it becomes law. That from then, anybody who makes an application from then will receive that will be extended. Their indefinite leave will be extended for 10 years instead of 5. Now, somebody just asked if assuming reform wins, uh, I think we are going into the realm of speculation. But one thing I need to say is that even if we want to take the threats of reform very seriously, uh, bear in mind that the current Labour government has 5 years to go. I think they've done one year plus. So they still have another 4 years to go. So I did not see a reform except something terribly drastic happens in this country. I do not anticipate a reform government in the next 3 years. So I don't think there's really much to fear. I think the reform threat is just to probably buy more votes, but I do not see that happening. But if Labour remains in power or the Conservatives come back to power, both of these parties do not apply their rules retrospectively. They apply from the day it is enacted. So technically, the transition period will apply to you. I
Okay.
hope that clears the air.
Yes. Okay, you've addressed that question already.
Yeah.
Someone asked, is English requirement for dependent officially in effect?
The English requirement for dependents has not yet taken effect as well. A lot has been affected by the change of these were some of the key policies of the last Home Office officer, Home Office minister. So, and I think they've set a date for that. I'm not very sure of the date right now for that to be implemented, but it was meant to come into force before the end of the year. I think they were supposed to implement that from November. But like I said, because of the new, we have to actually wait and see the policy direction of the new um, Home Office minister. The Her policy directions have not yet been made clear. I think a lot of things, the dust is still settling with her appointment. So whether she's going to carry on with with the policy of her predecessor is what we are not aware of. That's why I started with a caveat that we should expect a lot of changes within the next few weeks and months, probably before the end of the year. A lot of changes are going to take place because this new minister has a lot of things that she wants to implement as well. So
Mm.
we might be doing another update by between now and November, December. So you better watch out for this space.
Indeed. So just a quick question again. There's been a lot of these queries about the last threshold for skilled worker was like 38. Is it 3700, right? It's now moved to 41, is it 800 or so?
Yes.
Um, what happens if you met the threshold? Maybe you earn 39,000 and you met the threshold, right? You got employed and you're now due to renew your visa. Maybe you have got 3 years. You want to renew your visa for another 2 years. And now the threshold is not 41,000. Your employer is not willing to increase your salary to meet that 41 is 800 or threshold. What happens then?
Well, anybody who came in under the old threshold
Mm,
is covered under the transition period, actually.
okay.
So they can still, your employer will still be able to renew your visa at the current salary that you are getting, as
Okay.
long as you met the threshold as at the time that you were employed. So, like we said, it is one of the major advantages of UK immigration is this transition period.
Mm,
Transition period will always allow you to be able to fall back to the law as it was, or will we use the word legally as it were when you were granted your leave? So that's quite very important. The same thing applies, like I said, for those who are going for indefinite leave to remain. The same thing applies for those who have brought in their dependents in the UK because somebody had the same question about dependents. If I brought in my dependent, and then because someone was in a company where they renew their sponsorship every 2 years and but it's the same company. And then they were worried, oh, the law has changed, and the Home Office, are they going to say that my dependents can no longer stay with me and all that? I said, no. The only time the Home Office will implement that is if you move to another company, which is like that company is now issuing you a completely different COS altogether. And at that time, it triggers the new rules in your own situation. So, and that's where the problem comes. A lot of people have that problem where maybe their company is no longer able to sponsor them for one reason or the other, and they are looking for a job in another organization. So they get caught up with the new rules. But as long as you're being sponsored by the same organization and by the same company, the transition period should cover you, and you shouldn't have much problem.
That's a very good one there. I think someone shared something in that light. I got discussing with somebody last during the week, and he was saying, what happens to people who, I think it affects a lot of people within that maybe lost their sponsorship. We know people who came into with the care sponsor care health and care visa scheme,
Yes.
and the employers lost their license to sponsor. No fault of the lost their license to sponsor. And they might not have been given 30, 60 days notice, but automatically they have a short period of time to get a new employer.
Mm.
Let's they could not get a new employer. What happens to them? Can they, the 6 months, I mean, 2 months, I think they have 60 days to change the visa, and now it's 3 months, 1 year, they're not able to get a new employer. Where do they stand in this scenario? I know there might be people will fall within that category, just hanging around in the country without a sponsorship, and they don't know where they stand.
Yeah. They're starting, we need to start by saying, like I said, you are in big trouble if you are moving from one company to another, because once you are moving from one company to another, the new rules catch up with you instantly. And
Hmm.
that's where the problem is. So you are only covered under transition if you are still with the same employer. So that then the old rules apply to you. Now, for those who are stranded, it's a major issue in the UK right now. It's a very big problem. I've also had a lot of inquiries in that direction. For those who are stranded, one of the major things that they can do is to, I usually, this is my own solution to it, and I think a lot of lawyers have done the same thing. We advise them to make sure that they retain their Section 3C by applying for some form of leave to remain, under further leave to remain. And I think when the Home Office was contacted, the same thing, they themselves were confused. Home Office staff were also confused. They didn't know what to say, but that was the advice they were tilting to as well. Because for you to be able to maintain some sort of legal, I've done one for someone that worked, and it was quite a good, it came out positive. So we had a situation where the person had to switch from one company to another, and they gave 3 months, and then the 3 months expired, and they couldn't get a COS. So what we did, we applied for further leave to remain for them, and then when we did the further leave to remain, while the further leave to remain application, because that is technically to buy time, and it covers you under Section 3C. And while the further leave to remain was pending, they he got COS, and then we did a switch. So we made in application and switched that application, the further leave to remain application, which to the good news, which was a good news to everybody because the Home Office granted it. So that was
Hmm.
quite good. Yeah. So that's some of the things they can do.
Hmm. Yeah.
So
More questions?
Yeah, I just want to, based on the last question Anebi asked, what if you're changing job? For example, if you're under the healthcare visa, you're changing job after 3 years, maybe your current employer does not want to, they lost their license or they're not sponsoring you again, and you're changing job to another healthcare provider or another care home. Uh, I remember you said the new rule will apply there. Is that true, or will you still be able to sponsor your family, or does it still count? Or I
no,
just
the
want
new
to.
rule will apply once you are seeking employment from a new employer. The problem with that, the Home Office has actually played a fast one on a lot of people on that. That well, because they've changed employer, it's like a totally new employment to to them, and it's totally new sponsorship. Everything changes, and then you come under the new rule because you'll be granted leave under the new rule. So it becomes now what happens is if at the time that you are making that change, your dependents have already come into the UK with you, of course, you will be able to renew with them. Although we've had situations where the Home Office has said that they couldn't. But of course, under administrative review or appeal, that has already been turned down because the Home Office will be seriously infringing on people's rights if they retain that kind of decision. Where it becomes difficult is where you have not come in with your employer, with your dependents at the time when you are making that change. The Home Office always insists that it is a new, you are being granted leave under a new sponsorship. And therefore, you are, what will apply to you will be the new rules. So that's quite important. Somebody asked a question on Section 3C. How long does Section 3C last? Section 3C is very elastic. I'm going to take your question, Goya. I don't know if you're the one that asked the question, but Bro John, if you don't mind, I'll take about 2 more questions and then I will a kind of follow-up because I have a major church engagement in the next few minutes here. So Section 3C is very elastic. Section 3C does not have an expiry time. Section 3C is contingent on your application in the sense that the application date stroke when the Home Office makes a decision. Let me explain how Section 3C works. For example, if your leave is to expire, we are in, this is 25th of September. If your leave is to expire on the 24th of September or today, 25th of September, your Section 3C kicks in immediately you submit your application to the Home Office before your leave expires. Very important. You must make sure that your application enters in before your leave expires. Whatever application you want to make must enter into the system before the date of expiry. I always advise people to make their application at least 24 hours before their leave expires. That way your Section 3C kicks in. Now, that Section 3C continues. Now, you have put in your Section 3C in the hand of the Home Office until the decision is made or until you substitute that application with another application. So, because you can't have 2 applications in the Home Office at the same time. Once you submit another application, it automatically cancels your old application. So, it's a substitute application. So, the Home Office, your Section 3C remains in the hands of the Home Office until 2 things will happen. Either you substitute the application, like we said, if you have a COS, you can substitute it, or the Home Office makes a decision. The very minute the Home Office makes a decision, your Section 3C expires from that date. And 2 things can happen. They can make a decision and give you a right of appeal. If they give you a right of appeal, your right of appeal continues. I mean, your Section 3C continues by virtue of your right of appeal. So until you exhaust that right of appeal. If the Home Office does not give you a right of appeal, your Section 3C expires automatically after that decision has been made. So that's why I say Section 3C is flexible. It's not something you can actually put a date on. You can't say it lasts for 30 days or 1 year or 6 months or no. It all is contingent on the decision you take or the decision the Home Office takes. So I hope that clears the issue of Section 3C. So 2 more questions, please. Yes.
Yes, I think there's I think Wega's hand is raised up. I think Wega, you want to ask a question? Wega, if you're talking, you're mute.
You are
You're
muted,
mute.
yes.
Can you hear me now?
Yes, we can hear you now.
Yeah, I'm Grega. Yes. Basically, I want to ask 2 questions. If you have a COS that is already in existence, you are running about 3 years, and you are likely on the same skilled work visa and you want to change an employer too on that same COS, does it count? And if you have if the COS for 5 years and the new employer now give you still on the same skill worker visa, you understand, for care, does it count when you now want to do your ILR? Which one
Yes,
will you
the
look?
simple question is that the answer is yes, it counts as long as you're within you're still on your COS. Even if you're with another employer, it still counts when you are doing your ILR.
And for the dependent, everybody
Yes,
goes.
yeah, it does count, yeah.
Okay. Thank you so much. That's all.
Thank you. Final question before we go, or before I go, sorry. Yes,
There's a
Victor,
question.
Victor, yes.
Ijoma said, is it true that when applying for ILR, they will inquire into your and social media different address, and then maybe length, also addition to that, length of time in the UK. It looks like that could be an issue as well if you apply for
Uh, that's
ILR.
very interesting, very, very
Mm.
interesting. I've heard about that. I don't know if there is any policy on that, if the Home Office has developed any policy on that. I'm not sure if that has been implemented, but the only thing no, where that has become a little bit, Home Office is looking into is marriage visas. There's a lot of things going on around marriage right now, which I'm sure some of us are aware that previously, if you come in with a spouse and you now have a problem, some people come in with arranged marriage and all that kind of stuff. You have a problem, you report to the Home Office, oh, we now have we are no longer together. Now, the Home Office will want to investigate, and they are doing that now to find out about your relationship. Where is your spouse? What are you people doing? Where does your other spouse live? They want to contact your other spouse to find out what has happened with regard to your marriage. And if care is not taken, both visas will be cancelled because they are now discovering that a lot of people made arrangements to come in with spouses and all that kind of stuff. So that is the one I know. But the issue of prying into social media, to be sincere, I do not think there's any policy on that. If that has been implemented, then it could be I think it could be individualized. It may just have to do with with specific individuals. I'm not sure it's a policy that the Home Office is implementing as a body.
What about traveling? I heard that could be an issue now. If you travel a lot of the country, you must be in the UK for a period of time.
Yes, yeah, yeah. That's also been that's really being taken seriously right now. You must meet the first 3 years requirement and also the 99 days before the main application is made and all that. So there are people that have it also affects spouses as well, because a lot of spouses, I have very recent issues with husbands who their wives are here on COS, but they've got good business. And so some of them are staying abroad and they're wondering, how do I get my ILA when my wife and children are here? When they're applying for ILA, how do I get? I come in, I go out, I come in, I go. I said, no, that you can't eat your cake and have it. If you one of the requirements for you to have indefinite leave to remain is confirmation that you want to make UK your permanent residence. So your travel history will definitely be taken into account. And you must be able to meet with the immigration rules on that. If not, except you have exceptional reasons why you think the Home Office should exercise discretion in your favor in that. But that is rarely done. Home Office rarely do exercise such discretions, except it has to do with maybe medical or other reasons. So that is very important. And
Victor, just a very quick one, Victor, for you before we go. Just the last question for Victor.
yes, Victor.
All right, thank you. Just a quick one. You mentioned if you have an application before and then you put in for another one, I think it's called varying, right? Do we need to
Yes.
do anything to get the refund for the first application? Because I did something like that recently. And so I'm just wondering if I have to.
Which refund are you asking about? Is it IHS or Home Office fees?
Which NHS? The
Everything,
one
the
in
visa and the
immigration?
IHS.
Home Office hardly refunds the
Put it
Home Office
NHS
fees.
there, right?
Yeah,
Oh, that's
the
NHS. That's
reason
for three NHS. Yeah. Put it.
I'll tell you the basis on which you get refund.
Fees, okay,
Normally,
that's the one. That should be fine.
normally your IHS will be refunded, but immigration fees are hardly refunded, especially if it's gotten to the point where the Home Office has taken a decision on that. But if you are varying and you are withdrawing the application, yes, they will refund. Most times you don't have to do anything. Most times they will refund on their own, especially if it is IHS, they will always refund on their own. But if you don't get your refund within 28 days of withdrawal, then you need to write them and let them know that you are waiting your refund, and they will process that for you.
Thank you.
Thank you very much.
All right. Thank you,
Yeah,
Barrister George. I really appreciate your time.
thank you.
If anyone wants to discuss with him again, in addition to that, or you have a particular case in question, he's a lawyer. He's happy to assist with your immigration challenges. I put his contact details there. I didn't put an email, but I'm sure you can reach him on phone.
Yes.
He's very accessible and someone that I know for
Will I
many
be able
years.
to, okay.
And I'll be
Will I
happy
be able
to.
to ask a question or question is ended?
All right.
We'll
Thank
be
you,
happy
John.
to help you. So thanks so much, everyone, for joining today's session. And then let's connect again sometime next month. In the meantime, if you have any challenges, feel free to reach out to me, and then let's have some more conversations. Thank you, and have a very good evening. Thank you from everyone for Like Minds. Have a good evening. Thank you, Barrister George.
Thank you,
Yeah, thank you
John.
so much.
Thank you, everyone.
Have a good
Thank
evening.
you. We'll catch up
Thank you.
soon.
Thank you.
Bye bye now. Bye bye.
Bye.
Thank you, everyone.
Thank you, George.
Thank you,
Everyone.
John. Thank you.
Bye bye now. Bye bye.
Bye, man.
Good evening. Good evening now. Bye bye.
Yeah, good evening. Thank you so much. Appreciate it.